Yes, Mr. Speck.
Two housekeeping matters, if I may. On your bench, there should be the letter that I referred to yesterday, where I told you that I thought I'd seen a letter indicating that the Supreme Court in China had set aside the decision in InterDigital. And this is the letter, and it's the last two paragraphs, this is a letter from InterDigital solicitors to Huawei solicitors asking that be brought to this court's attention if reliance was going to be placed on that judgment. Yeah. So I thought I ought to show you that because I referred to it without having a clear recollection. Yep. The other housekeeping matter is to let you know that I intend to bump up to immediately after the propositions that I'm just about to go to, what I'm calling issue 5, so as to deal with the points that, in particular, my Lord Reed were putting to me yesterday as to what you get when you look at the undertaking.
Yes.
I anticipate that your Lordship's quite anxious to know what our case is on that, so I thought I'd bump it up so that you hear it sooner rather than later. But before we get there, I've got a series of, I'm calling them propositions, and most of them are just that, but they're big picture points that I want you to see and have a handle on, and I hope that they'll give you some structure for deciding actually both issues 1 and 2, because in my submission, some of the points that were being made, the submissions that were being made on behalf of Huawei, were really muddling everything up and not being very clear about what points went to what ETSI actually did mean, what points went to a jurisdiction point, and if so, which limb in issue 1 we're talking about, and what were points that were complaints about forum, and actually what were complaints about particular claimants in this case, which I think, as you appreciate, I'm going to come on and explain that is relevant.
Before you go into that, can I just mention one matter which, at some point or other, would be helpful if you were to deal with. You were explaining yesterday that, properly understood, what is payable for the portfolio isn't actually a royalty for any patent in the ordinary sense, but rather you're looking at a job lot and you're taking a view and you're deciding what's a reasonable price to pay for this portfolio as a whole, some of which are liable to be valuable intellectual property, other items that it may not be valuable. So if I'm wondering, I think I'm not the only person who may be wondering, if that's right, I'm wondering how, and I'm not expecting you to answer this just now, but at some point it'd be useful to know how that relates to the provision which Mr. Justice Burse thought was appropriate to have in the license for an adjustment of the amounts payable in the event that there were rulings on the validity of patents. And it might also relate to the question that arose in the conversant litigation about the relationship between the between the English proceedings and proceedings going on in other jurisdictions where a royalty might actually be fixed by the court of that jurisdiction. You understand the point?
I do understand the point. And I hope that you might see how it fits in to the case when I go through the propositions. But just to give you a heads up on the first limb, the mechanism does not affect the price every time any individual patent may be found to be not essential or invalid. That's, as it were, as a run-of-the-mill event, is priced in to the patent. Yes,
that's what I was wondering. Yeah.
What it does do is it allows particular patents or regions which might be particularly important. So you could have a mechanism which, if a particular country, the patents went, the royalty rate went to 0. And so it allows and gives a purpose to implementers, the public, to actually attack patents where they're particularly important to the price. But the general scheme is that knocking out the odd patent here or there doesn't affect the price because you know that that could happen.
Yes, exactly.
At the beginning. But what it does is it allows, it looks at all the circumstances of the case. What kind of circumstances might you think might arise whereby the patent coverage either goes away completely, or in fact what Mr. Justice Burse's mechanism does is if the patent coverage drops below a particular level, you go down to a lower rate because the coverage becomes more susceptible. Now, the reason it doesn't do that for China, in my submission, is that nobody contemplated that China would ever be knocked out. It doesn't go down even lower. China's already in the lower rate. And so the reason it doesn't go any lower for China is nobody thought about that. It's just a forensic point that my learned friends make now. And of course, the reason it doesn't go any lower for anywhere else is because they always manufacture in China. This is a license which was, I think it was a 7-year license. I might be wrong about the precise period, but it's a limited period. And in the course of that 7 years, nobody was anticipating that they'd knock all the Chinese patents out. And in fact, they haven't. So the point they're making is a point that it hasn't happened. There's not a problem. But if before Mr. Justice Burse, the position might have been, well, you've only got 1 or 2, and we think we're actually going to go there, knock them out, what would have happened in my submission is the mechanism would have allowed for it. So I hope that that is a bit of an answer to at least the first part of the question that my Lord's put to me. And I hope that actually when you see some of the propositions that I put to you, and when I explain how the mechanism, how the ETSI policy works, you can see how that fits in. Because basically, if there's been no litigation, you have to license it. But if there has, the obligation comes out of the obligation. We're always talking about the obligation when you're entering into the license, and I'll come on to it and explain.
I thought it might be helpful because it might well affect the way you present some of your later arguments.
Well, it might, but I think everything I'm going to say to you is consistent with what I've just explained. Now, can I start with these basic propositions? The first one is this: a contractual restriction limiting when and how an owner of patents can enforce its patents is not the same as the legal rights under the patents or their enforcement. Just by a little bit more of explanation, in particular the idea that contractual restrictions on a party over enforcements of territorial IP rights are likewise territorial, because the underlying IP rights are, is a false one. In fact, I go further than that. Ordinarily, such contractual limitations that are agreed are in fact international. What is an ordinary patent license? So outside the standard essential patent context, that is an obvious example of a contract that limits or restricts a patent owner's ability to enforce his patents. Similarly, real-life licenses in the SEP context. And, my lords, my lady, this case is just another example where there's a contractual limitation, here an obligation to offer a license, that is not territorial limited in the way that the underlying IP rights are. In fact, I can point to other SSOs and undertakings given to them where the undertakings express on their face that the undertaking is to offer licenses on a worldwide basis. And of course, if my friends are right in their jurisdiction objections, then the courts here or elsewhere around the world can simply not give effect to the proper effect of that contractual undertaking. make that point good, I'm going to show you two, not in mobile phones, but standards like wireless LAN and video coding.
Is that the ITU?
ITU and IEEE.
Yeah.
My lord's ahead of me, yeah. But let's go to ITU first. It's tab 16 of the supplemental bundle. And we need to go, if we can, to tab 16 MS 10645. This is a scheme where you can make a declaration that either specifically identifies patents or just a general one. So there are in fact two documents. If you're notifying rights to say you're not willing to license, you obviously have to specifically identify the rights. And so when we look at the documents, you'll see that the one where you're specifically identifying rights can do that as well. Anyway, if you are offering a license, you can do it free of charge or for a reasonable fee, and so you have to elect. And let's have a look at the declaration on 10659. And it's box 2, where you elect for offering a license involving a payment. And you see the declaration is to grant a license to an unrestricted number of applicants on a worldwide non-discriminatory basis. And the general form one, which can only be used for, in effect, boxes 1 and 2, is the same. That starts on MS 10611. And it's box 2 again over the top of the next page. Same thing. And while we have it open, can I just show you, even in the case of a free of charge license, that is not giving up the right to require that there is in fact a license. If you go to 10648 and look at the passage bridging that page, so I'm right at the bottom, over to the top of 10649, still entitled to a license, right at the top. And that goes to the point that I made yesterday, that damages in lieu is not the same. The second one I wanted to show you is the IEEE, which is in fact the next tab, tab 17. Starts on MS 10663. And the declaration is at the top of MS 10688. Starts a little bit earlier, but the bit I want to show you is at the top, and again it's second option, box B, and there you see worldwide basis set out in the second line.
This is 10.
So right at the top of 10688, I'm picking up in the middle of the declaration because that's the bit I need. Box B, second line. If you tick that box, that's the declaration that you're making. (10688). Has my lord got it right at the top?
Right at the top, right.
Yeah, it's the box right by letter B.
Yes, I have the choice. Thank you.
And while we have this one open, if you go back to 10682, and note the second paragraph. What that's dealing with is circumstances where an injunction won't be available, but it makes it absolutely clear that it is where there's a failure to engage or to comply with the determination. That's the second full paragraph. So these people consider injunctions are on the table in those circumstances. I understand my friend's arguments. The court doesn't have any jurisdiction to actually give effect to that regime. My second big picture proposition is this. There's a difference conceptually and as a matter of substance between a royalty payable under a licence and damages payable as relief for infringement of a particular patent. Elaboration. A royalty is the payment of sums due under a contract in respect of a particular activity, say the manufacture or sale of a phone. Damages is the sum payable to compensate for the loss caused by the defendant's acts of infringement under a specific patent or patents that have been litigated. Position 3 leads on from that. The payment of a royalty under a licence to a portfolio of patents is not payment of damages for infringement of each individual patent in the portfolio, nor is it predicated on any assumption that all the patents in the portfolio would, if litigated, turn out to be valid and infringed. The point I'm making, just by way of a little bit of elaboration, is the royalty is not specifically attributable to an individual patent. It's simply a contractual payment made for the permission to do a particular act. Parties enter licenses under portfolios, particularly very large ones, knowing that some proportion of the patents would, if it was ever practicable to litigate them all, turn out to be valid and infringed, and some proportion would not. Practical consequence, that reality is priced in to real-life licenses. So, when, as in this case, one looks to real-life comparable licenses as a guide, it's priced in to the royalty that you're looking at. Let me illustrate that simply. Let us say you have a comparable license on a portfolio of 10,000 patents. You are valuing a licensing royalty to do much the same acts under a portfolio of 5,000 patents. Simple approach you may take as your starting point is to halve the royalties. The proportion that you, if you ever could litigate 10,000 that would end up failing, would be mirrored, you think, in the 5,000. 30%, 40%, whatever it is. That's built in. You scale the royalty by 2, and that's built in. In fact, in most cases, one will try to be more sophisticated than that, to try to take account of differences to the extent to which there's possibilities of over-declaration. And you allow for the challenges in national courts, if they're particularly important, on the circumstances of the peculiarities of that particular portfolio that you're looking at. as a starting point, it's all priced in. Just as an aside, although it's not strictly what we're arguing about today, that's why in patent law you often see people say a reasonable royalty on a single patent that's been through litigation is worth a lot more than a reasonable royalty that hasn't. Because that's just taking account of the same uncertainty and applying it to a single patent. And real life people would agree a different royalty because of that. Four, determining FRAN terms, whether they're global or otherwise, does not involve adjudicating validity or infringement of any patent, foreign or otherwise. Don't forget that on the argument that the correct answer is a UK national licence, what they're suggesting is that the implementer can be compelled, or at least he is given only the choice of the injunction or a licence that covers the entire United Kingdom portfolio. But that does not involve adjudicating on the validity of those patents. And it's the same when one has a global portfolio, a global licence. What the exercise does involve is assessing what reasonable commercial people would agree in the circumstances for the freedom or permission to do the particular acts. Say, to make or sell a 4G telephone. That involves an assessment of value of the licence or permission. That is a commercial factual assessment. It is why both parties adduced huge quantities of evidence directed to that exercise, but it didn't involve any adjudication on validity or infringement of a patent. As Lord Kitchen explained, let me show you that. It's paragraph 79. So I think that's MS 504 in the Core 2 bundle.
Sorry, could you give me that number again?
MS 504.
Thank you.
This is the paragraph where he identifies confusion in Huawei's submission where they're aligning two separate things. Right at the end, you see that sentence. The judge made no finding as to the validity or essentiality of any SEP in any other jurisdiction. And he actually expands on that in the bottom half of paragraph 80. Now, my friend showed you an earlier version of the ETSI policy.
Sorry, just to interrupt, just to see if I'm following this. He did, of course, make an adjudication on the validity of the UK patents that were being relied on to seek the injunction.
To seek the injunction.
Yeah.
Patents in suit.
But on your view, that wouldn't. He didn't have to do that in order to put a value for the valuation exercise.
Exactly.
Yeah.
And what he didn't do is have to adjudicate on the other UK patents in the portfolio.
Yes, the only relevance of validity was to get you off the ground in seeking an injunction.
Exactly. Well, what it comes to, just so you know where I'm going,
Yeah.
my client's interest is in the courts enforcing both the property rights and the Etsy Frand undertaking. If you fail to do either, we're in trouble. Validity on the patents in suit go to the injunction, and the valuation of the license, the valuation goes to the license. And the reason you have to enforce both is because implementers are not yet on the hook on either, and they have to be put in the position of choosing whether they're in the Etsy regime or not. My friend showed you an earlier version of the policy, which in fact we think was passed but never implemented. There's an explanation of this in Qualcomm's intervention. But it doesn't matter for either of our arguments whether that's right or wrong, I don't think. You may recall it had an arbitration clause over disputes on the undertaking. It's in Appendix 9. Can we just turn it up? It's page 3110 for my Lord Reed, but on the MS numbers it's 3583. And I have to confess to being rather puzzled as to how my friend thinks this helps him.
Just remind me what this document is.
This is the 1993 Etsy.
Yeah, it's whether it actually was, it was passed.
Oh, yes.
My learned friend said it was an earlier version of the policy. It definitely was passed, but there's a point as to whether it was ever actually being used. But that doesn't matter, either for his point or for mine.
Yes.
And the reason I can't understand how my friend thinks it helps him is because it recognises that disputes under the undertaking can be determined without adjudicating validity and infringement. Because it specifically excludes that from what the arbitration can deal with. If you go over to the next page, (19.9) is the clause I want you to see, please. That is a recognition as precisely what I'm submitting to this court. And as I think you've got the message that just because all declared patents are included doesn't mean you're paying for more than you need. Licensees want as many patents included in the license as possible. It gives them certainty. So long as the price and other terms are the commercial matter negotiated in the circumstances, which in this case was subject to extensive evidence, once you've come to the price, what's covered by the license? As I say, it doesn't matter. In fact, it does matter to the licensee because they want more patents in for absolute certainty. But this is just the same point as my point that you appreciate that some of them will turn out not to be valid and infringed if you litigated them all.
I'm not sure I understand why the licensee wants as many patents as possible. If we imagine, for example, a licensee who is concerned, who has no interest in infrastructure, for example, why would he want...
That may be so, but let's say we're not actually talking about that, we're talking about the declared ones, so those that are in the frame. What the licensee will want, let's say it takes a view that some are really shaky, and so they don't add to the value. You say to the licensee, you want them in the licence or not? They don't add to the value. The answer is yes, please. Because they don't want any risk that they can be sued and it turns out that they were wrong. Think about a royalty-free licence, my lord.
Whether they want them depends on whether the price goes up by virtue
Exactly,
of
that's my point. It's
inclusion.
exactly
But if
my
it doesn't
point.
go up, then there's
If
no
the price
point
doesn't
in
go up, they
arguing,
want them. Exactly, that is my point. If the
even if
price-
they're useless in the end.
Exactly. If it doesn't affect the price, they want them.
Right.
That's my point. And because the pricing exercise is a different exercise, they're not paying for something that they don't want as long as the price isn't going up.
That's quite a big if it doesn't affect the price, in the sense that one starting assumption is that the whole portfolio will license at a higher price than some selected little bit of it chosen by a particular implementer.
Well, I'm going to come on and explain how it works.
Yes, I mean, I appreciate that may not be how pricing of global licenses work, but one has to bear in mind that the pricing exercise being conducted is of a global license.
Indeed. I'm just concerned to address the point that appeared to emerge in an exchange between my Lord Reed and my learned friend. There's any patent in there that turns out to be invalid or not essential, they've paid for something that they didn't need and they're paying more. It's not right. The valuation is done on the basis that you know you're going to get the whole lot, some of which will turn out to be things that you didn't need. At that point in time, they did need them because you don't know which ones are valid and which ones are not.
It would say, you've explained that other things being equal, a portfolio of 10,000 patents will be worth twice as much as a portfolio of 5,000. Now, say you're somebody who has no interest in the infrastructure side of the industry, and 5,000 out of the 10,000 are actually infrastructure-related patents.
Then that's different. Mr. Justice Burse's license dealt with infrastructure and phones separately.
Yeah.
Let me pick up on an analogy that my
Right.
Lord put to my friend. What I'm talking about here are all the patents that cover my Lord's violin.
Yeah. Okay.
We're not talking about the bassoon patents. Everything you need to make a violin. So actually, some of them, there'll be some invalid violin patents. There's 10,000 of them. You need them all.
That's much clearer. Thank you.
And so, actually, I've now understood what's troubling my Lord. That paying for patents that you don't need in the sense that it's a bassoon, that's not the issue. My friend is saying, I'm paying for patents which may turn out to be an invalid violin patent.
Yes, yes.
So if there were a manufacturer, an implementer, who simply produced handsets and not infrastructure equipment, then the operation of the FRAND process would allow that entity to say, I'm only interested in the handset patent. Yeah.
I mean, they'd have one half of the burst license. That would be the exercise that you'd be doing. And in fact, there are some technologies where there are kind of competing ways to do things. So you might have somebody who has patents on violins and bassoons, and you see in the rules or the cases that say you can't require the license to be to the competing technology. That doesn't mean another violin patent. It means you can't throw in the bassoon patents and bump the price up. And that's obviously quite right. But that's not what we're concerned with here. We're concerned with making them take all the patents that they need for the violin.
But is that an accidental consequence of the fact that Huawei are interested in infrastructure and handsets? So that in a sense you can say of Huawei, in this case, they actually want violins and bassoons, and their real complaint is having to take invalid patents for them.
Well, insofar as they want violins and bassoons, they've got a license that has a violin way of calculating a rate and a bassoon rate. So they, in effect, got the two together. But the complaint that they've got to take the whole lot to make violins is just nothing to do with the fact that it also deals with bassoons.
So you say the valuation process used in the industry and adopted by the judge doesn't simply treat global as meaning global right across G4, but has subdivisions for handsets and infrastructure.
Yeah, exactly, yes. There are some patents which are only infrastructure. There are some actually that are both, because they deal with a method of communication between the two. And there are some that are only handsets. I'm reminded that the Conversant case is a case where they're only seeking a license on the handsets. Soon, or the violin, but it's a single instrument license that's being sought.
When you say they are seeking, or you mean Conversant is
Conversant,
seeking
yeah.
to require them to enter
Well, they're
in?
suing them for infringement on handsets, so the
Yes.
draft license, they say, are the Fran terms, relates to handsets. And I think I've made this point, but just to make sure I have. The objection that he's making would apply to his stated position of a single territory license anyway. Proposition 4 over. The fifth one is that there is a substantial and significant difference between a situation where a license is in place and a scenario where there is none, but a court orders some payment of money. Beside the practical difficulties of how you ever make an order for a running royalty payment, akin to a damages payment like that, how do you police it and get information about it? Or, in fact, what on earth, my friend's alternative suggestion of a lump sum, how you would do that? I think he said for only 5 years. How do you calculate that? It's obvious it has to be without any reference to sales, and why am I being limited to 5 years? But leave aside those difficulties, the point I'm making is broader. A license is much more than an assessment of a royalty rate. It includes many other matters over which parties negotiate, because they're important. Terminate the term of the thing for a start, before you decide that the parties renegotiate in the light of the commercial scenario at that later state. And as I think I foreshadowed yesterday, a license includes the provision of consent by the patentee, which the order of payment doesn't, and often things like express agreement not to sue customers. So those things will have an impact on the law of infringement by others or the law of exhaustion. They sometimes allow sub-licensing. None of that arises if the court simply orders money. Undertaking that SEP owners give is to make a FRAND licence available, not to limit itself to monetary remedies. And that's how my friend has put his case, though. Let me show you, it's perfectly blatant. If you turn up his reply, so I'm now in the supplemental bundle at 10406. Looking at paragraph 58.5, second line, that's what he says we've done. We haven't. And when we get to it, I'll show you that Huawei knows very well that's different, and they also know that a patentee doesn't undertake to tolerate use of its patent without a FRAN licence and simply to limit itself to the pursuit of damages claims. Yet that's the case they advance before this court. Six I can take quickly because I foreshadowed all the matters yesterday. It's this. Like many other standard setting contexts, the standard setting regime that we're concerned with in this case, ETSI, is international in nature. And I pray and aid all the points I've made yesterday. The standards are international, the markets supported by them are, and the undertakings given by the patent owners have international effect. Seven, there is a fine balance in standard setting and the regimes that enable it to take place. The point of standard setting is to promote the standards and the markets they create for the ultimate benefit of the public. It is not all about protecting and benefiting implementers, as the appellants claim. Always miss out the other side of the balance when referring to the policy. Can I just show you a couple of key clauses? I'm looking now in the annex to the Statement of Facts and Issues, so I'm in Core Volume 1, MS 138. Clause 3, policy objectives. What is needed is the balance of the rights of owners of IPRs together with the access for the others. And you see that referred to, first of all, right at the end of 3.1. And you see that explained further by 3.2. It explains what on that side of the coin you need to achieve. Adequate and fair reward for the use of their IPRs in the implementation of standards. I think you may have seen it already, but we spoke about family members yesterday. Clause 4.3, so over the page on 139, is the thing that automatically extends a declaration for any one of those national patents. It covers the rest of the family. Proposition 8. There will be circumstances where it's not fair or reasonable to expect a patent owner to negotiate separate licenses with an international implementer, patent by patent or country by country. That is precisely a point made by Lord Kitchen in an important paragraph of his judgment. It's paragraph 56 on MS 497, so I'm in Corp Volume 2. I'm particularly looking at the bottom half of that. This is where he's talking about the conclusion as to whether global license may be frowned. It's not only self-evidently true, but it was agreed in substance by Huawei's witness. You've seen the evidence already, but you can see that Lord Kitchin was referring to the impossibly high costs of litigation right at the end of paragraph 55. That's Mr. Cheng that he's referring to. You've seen that already. My friends are wrong when they seek to suggest that when it comes to assessing FRAND, the court should draw a distinction between what people do consensually in real life and what a court should do in disputes before it. They were right to have regard to real life licensing and practices in the field in question. I might add, both parties approached it like that. Cases indicate that the FRAND regime, are intended to promote and achieve parties to disputes to promptly conclude licenses in accordance with normal practices in the sector concerned. You might think that's what we look to. Moreover, as I think I foreshadowed yesterday, that suggestion that there should be a difference of treatment is an argument for a two-tier system. It will discriminate against those who do enter into licenses, essentially, and in fact, it will lead to more and more not, will heighten the incentive to hold out. Section 10. Contention that the appellant should not be required to license patents they dispute is in fact a point which is directed to timing. To unpack it, what it really amounts to is a suggestion that the implementer should not have to take a license on patents until the disputes are determined. Happily for the appellants, as it's not a reasonable or practical thing to do, for the vast majority of patents, that is kicked off beyond the long grass. It will never happen. But in any event, as I shall show you, it is considered that it is not permissible for a potential licensee to condition the entry into a license on the prior finding of validity of infringement. That's all the condition, all the argument is a point on timing. This quickly, the arguments that the appellants shouldn't be required to license patents they dispute is in fact an argument, like all of its others, that doesn't even support the position it's adopted, that of country by country licensing. Appellants are doing, and what implementers will generally do, is to seek to enforce the undertaking to offer a licence so as to avoid the injunction, but at the same time not take the licence which the scheme provides the patent owner is obliged to offer. That's a point I flagged to you yesterday. Why it's so important that you uphold both. Issue 14, which is related, 13, related. Last one. My clients have subjected their monopoly property rights to the ETSI regime. They have an interest both in that regime being upheld and their property rights being upheld in that context. It's simply unreal to suggest, as my friend did, that all we have is an interest in securing nominal royalties on the odd individual patent as and when they may secure judgment. To my Lord Reed. What this is all about is patent owners are already locked into the ETSI-FRAN scheme. They've given the undertaking. Implementers like to avoid both the enforcement of the property right, i.e. the injunction, and taking the FRAN licence. So they're neither in or out of the FRAN regime. They're getting the benefit of purporting to enforce it, but they're not taking the FRAN licence. That is until a crunch point, when they have to decide, are you in or out? That point is when a FRAN licence is available, so the dispute about FRAN has been determined, and they have been found to be infringing a valid right. I say to you, this case is about you upholding both the property right and the FRAN regime together. Fail in either, patent owners are left with no effective relief, and it's basically the regime becomes a charter for holdout. In fact, that's the substance of the paragraph that my learned friend criticises in Lord Kitchen in paragraph 111. It's what he's identifying, is that problem. So it's Lord Kitchen 111 at MS 510. Sorry, it's Core Volume 2. He's identifying there. He's getting no effective conjunctive relief. Now about just below halfway through. Just getting, here he's obviously considering country by country, but it's even worse on my friend's new case. But here he's considering a situation where you sue in a country, they say they're enforcing the right, but then you only get the royalties for that place. That is in substance what he's talking about there. And just to deal with a point that my friend advanced in criticising the word entitled in that penultimate line, the position that he is considering is the implementer enforcing the FRAN undertaking against the patent owner. You see, about 6 or 7 lines up, he talks about no effective injunctive relief. So he's referring to when that undertaking is enforced. And in that case, the patent owner is entitled to the royalties. The word is royalties, not damages. We It ought to be, because if he is enforcing, sorry, if the implementer is enforcing the FRAND undertaking, he ought to be paying under the FRAND licence. Now, all of those matters are important big picture matters for my lords and my lady to keep in mind. Move on and address what I'm calling issue 5, the issue that I'm bumping up the order to address my Lord Reed's questions to me yesterday.
Just ask a factual question. In the Unwired Planet case, do we actually know how many patents were in the worldwide bundle and how many were in the UK bundle?
I certainly stood here, I can't tell you, but I can find out.
But does Miss Justice Burst deal with that at some point?
Are you asking about families or actual patents?
No, actual patents that would be covered by either a global FRAND license or a UK-based FRAND license. In other words, the two licenses he set out.
I understand. I certainly can't tell you stood here, but I will find out. If it's in the judgment, I'll draw your attention to it,
Yes.
but the parties ought to be capable of agreeing it.
I would have thought so. Thank you.
Can I address issue 5 then? The proper meaning and effect of the ETSI undertaking, which, as you know, is a French law contractual undertaking. Can I do it by reference to having an example in our heads while we look at the text? And so let's consider an example where I'm an owner of a portfolio of, say, 4G patents that are declared essential. Say there's 1,000 of them. Now, the obligation requires me to offer a licence to those that are in fact truly essential. That is the obligation at all times. But without litigating all of them, we can't definitively say which they are. As a practical matter, to comply, we must offer a licence which covers all of them. Now, offering all of them to comply is reinforced by the description of what I actually have to licence. I have to licence an implementer to carry out particular acts. I have to licence an implementer to manufacture, sell, use, operate, and so on, equipment. This is clause 6.1, referred to in the undertaking itself. And 6.1, if you were looking at Appendix 9, which I certainly think my Lord Reed was looking at
Yes, I've got it on page 3161.
Yeah, exactly, 3160 to 2. So those 3 pages, which is MS 3634, I think.
Yeah. But your point is sufficiently made on 139, if that's what we happen to have open, is it? MS 139.
Probably. If
That's
all
where
you're
it's the appendix to
That's it.
the facts and issues. Yeah,
I think so.
yeah, that's where you were last time.
I think actually you might need Appendix 9 because I'm going to take you to the definition of equipment.
Oh, yes.
That's
Yeah,
I
okay.
remember now. There is a reason why I'm going.
Yeah.
But clause 6.1 right at the top of MS 3634, which is 3161 in Appendix 9, what I have to license are particular acts. I have to license the person to manufacture or sell or use equipment. That is a defined term in clause 15 on page 3165, which is MS 3638. Down the bottom of the page, any system or device fully conforming to a standard. So I have to permit implementers to make and sell such a thing. And that thing, because it's compliant with the standard, will use all of the patents which are in fact essential. It uses all of the violin patents. Now, at this stage, we've not spoken about price at all. And that analysis that I've just given to my lords and my lady is true, whatever the price or the other terms. As I've already foreshadowed, the question of price or other terms involves an assessment of what would be fair, reasonable, and non-discriminatory for such a licence. But that doesn't involve any assumption that all or any specific patents are in fact essential. In fact, as I've said many times, that's priced in.
Just help with the words of 6.1, please. It talks of licenses on terms and conditions under such IPR. What's the under such IPR about?
That's a common language to talk about the rights which are licensed. It's a common way of saying these are the rights licensed.
So it goes back to the essential IPR that you declare at the beginning, that turns out to be truly essential.
Yes.
And then
Exactly, yeah.
Yes. So really, you accept that the clause is referring to IPRs which are in fact essential, but you say in practice it's impossible at the stage of giving a license to know which of the declared IPRs are essential, and therefore in practice the license has to be of a whole lot.
Well, the obligation, we're talking about the obligation on me as the patentee. I'm going to actually illustrate a little bit what happens when you sue on one or two, because that's illustrative.
But have I understood this correctly? I mean, the obligation is confined to the essential IPRs, but your point is that without litigating every patent, you can't tell which of the declared ones are essential, and therefore you're not.
It's confined to those that are essential, but it's not confined to any one. It's confined to all of the violin patents.
Yeah. Well, all of the ones which are essential.
Exactly, all of the ones which are necessary for the violin.
And you say to implement that obligation, given the state of uncertainty, you have to offer the lot.
I do.
And is that reinforced by the way 6.1 works? Because the undertaking relates to when it's an undertaking in relation to such IPR. That's the end of 6.1. At the beginning it says, when an essential IPR relating to a particular standard, etc., is brought to the attention of ETSI. Now that's presumably only done by making a declaration.
That's right.
So 6.1 contemplates that the process of bringing essential IPR to the attention of ETSI is by the SEP declaration. And it's in relation to what is brought to the attention of ETSI by the SEP declaration. That's what under such IPR appears to mean at the end of 6.1.
Exactly.
Well, I wonder, the declaration itself is on page, well, in my copy, it's on page 3168. I'm afraid I don't know what the MS number is. But you're making the declaration at the stage when the standard is being developed, or the technical specification is being developed. And so the standard itself isn't in place at the time when you make the declaration. So it's impossible at the time when you make the declaration to know what will prove to be essential. And so where is it? Yes, the information statement, which is about a third of the way down the page, in accordance with clause 4.1, and indeed it follows the wording of 4.1, the declarant and its affiliates hereby informs ETSI that it's their present belief that the IPRs disclosed in the attached statement may be or may become essential. So there's the uncertainty about what is essential at that stage, but then the declaration underneath it is that to the extent that the IPRs disclosed in the attached statement are or become and remain essential, the declarant and or its affiliates are prepared to grant irrevocable licenses under this or these IPRs. So the problem is, I think, the practical one, rather than one that follows just as a matter of textual interpretation.
There's an additional practical one at the stage where the standard still is developing.
Yes.
It's undoubtedly right.
Yeah.
There's envisaging declarations.
Yeah.
If we move forward to where the standard has been set, you still have the problem of not knowing which ones are or are not.
Yes.
Because you haven't been able to litigate.
Yeah. Yeah.
Now, thus far, I've been considering a situation where it's done consensually. And I make this point, it's the same obligation, therefore the same question as when the parties are before the court. The obligation hasn't changed, it's the same. And so what I've just been talking to you about is a consensual one. Let's consider now having sued and succeeded on one patent. All the other patents, the other 999, are still in the same situation of not having been litigated. The obligation is the same. I must license everything needed to make and sell the equipment. And the question of how you price it and the other terms is the same.
Can I just have a look at the practical? If you're the patentee and you have things which are or might be standard essential patents, you've got to declare them and you have to license them. And you do that not by licensing those individual patents, but by licensing the manufacturer of the thing which is inevitably going to use them. And therefore, what you're looking at actually when you try to fix a price for this is to see realistically how many of these things, how many valid things, how many iffy things there are going to be in me, the patentees, my portfolio, that you are having to pay for on the FRAND license. Is that how it works practically speaking? Right.
Well, you have discussions about what the portfolio looks like. They are engineers' discussions, as I think one of my friends said, and then you have commercial discussions.
What alters it is the fact that you're not licensing these particular IPRs. You are licensing the manufacturer of the thing which inevitably is going to include them.
Well, I'm going to come to the point that I think my neighbour's getting at, is that license an individual patent because you're required to give permission to do the acts. That is the point. You can't do it. You're required to give permission to do the acts. How can you give permission to manufacture a phone on one patent out of your 1,000 when you actually say you've got another 999 that they're not taking a license under?
That wouldn't deal with the worldwide problem. That would deal with the, you might then be confined to manufacturing it in this country.
But his point isn't a worldwide point. That's my point. His argument is actually going to any portfolio. He wants to be able to say he can. His argument doesn't actually support the worldwide national point at all. It's a point that would apply to the portfolio that I'm explaining to, or using as an example, whether it was a global one or whether it was 1,000 patents all in the United Kingdom.
The patent by patent argument that is correct.
Exactly. And that's no doubt why my learned friend Mr. Block was so keen to disavow it. And just to show you, the obligation is obviously on the patentee, what they must offer. But just to jump ahead to a document that we're going to be looking at again later, in the Authorities Bundle 8, tab 148. This is the Commission communication. Sorry, MS for the front page is MS 9539, and the page I want to show you is 9550. Looking right at the top, and what this goes to is several matters. But the key thing for current purposes is not only does, as a practical matter, the patentee have to offer it all, the implementer is expected to take all that he needs. And I'm looking in particular at the paragraph right at the top that says, in this context, SEP holders may offer more patents including non-SEPs. That's implementation patents, but they can't require a licensee to accept them as well, accept that. But then it goes on, a general non-willingness or non-acceptance to offer or accept all the SEPs that a licensee needs may be an indication of bad faith. Don't forget this is in the context of the Huawei and ZTE dance. So they say in order to be found, the counter-offer, that's what the implementer has to make, needs to relate to all SEPs that a licensee needs and cannot be based on individual patents only. And just to complete it, the last sentence, portfolios should however not include competing technologies, only complementary technologies if necessary. That's the bassoon violin point. So you can't require the bassoon to be taken, but what you can, what you're expected, or what's expected of the implementer is to take everything they need for the violin.
Yes.
At this stage, they're in the same position as the patentee.
But I think the implication of your submission is that what the Commission is saying here isn't actually correct, because they're using SEP to mean, one sees it on page 9540, line 6, a patent that protects technology essential to a standard is called a standard essential patent, SEP. Now, you're saying that in practice, SEP holders are obliged to offer non-SEPs because, well, they're obliged to offer patents which they don't know whether they're SEPs or not.
Well, they declare, they contend that they are. They certainly recognise that in litigation, in their whole category, it'd be absurd to think that you're going to succeed on every patent in these matters.
Yeah. So they can't be confined to licensing patents or the use of patents which have been established to be SEPs. Because that's just practically impossible.
And my Lord, just be absolutely clear, that in my submission where they talk about a non-SEP is not talking about patents that have been litigated. That is the distinction between SEPs and implementation patents in my submission there.
Yeah, I understand.
You can't bundle together an extra bell or whistle that might go on the violin or the phone, because it's not necessary. But what you can require is that they take everything that they need. The fact that different courts in different cases use different approaches to calculate FRAND simply reflects that the valuation exercise can be approached in different ways. But the exercise is ultimately the same. Working out the fair terms for the license required to be offered, to do the acts which are being permitted.
Can I just make sure I understood the timetable for all this? Paragraph 6.1, or clause 6.1, contemplates that the, as I understand it, that the irrevocable undertaking will be given within 3 months of the declaration of the SEPs.
Well, it's within, yes, there's an immediate request.
Yes,
And
so
then 3 months, yes.
the owner declares makes his SEP declaration. The Director General then says, right, you must get within 3 months give an irrevocable undertaking. And that's presumably available to be enforced by an implementer as soon as it's given. How does that relate to the, and you say, as I understand it, that the declaration can be made before the standard is settled?
They can be, yes. That's certainly what's envisaged, whether that actually does that.
Because you would need to know, I mean, ETSI would need to know whether somebody was prepared to give the undertaking before they decided whether to incorporate the,
That's
the
the
patent
Yes.
into the specification.
That's exactly
Absolutely.
the purpose of what's envisaged
Yeah.
here.
Yes.
That the idea is, you say, look, I've got this patent, and they would not, they would take it out, or consider taking it out, if you wouldn't give the undertaking.
So if the extent of the
undertaking.
undertaking...
6.3.
Exactly.
That if the undertaking hasn't been given, then the committee chairman and so on discuss, well, are we going to have a different standard?
Yeah.
Yeah. But the undertaking is looking forward to the point in time at which there is a standard in place, and is undertaking to the extent that his IPRs are essential to that standard, he will make them available by way of license.
Exactly.
And presumably implementers want to get on and start their process of planning their manufacture the moment the standard is settled.
Well, certainly the moment the standard settles, they want to be hitting the floor running.
Yeah, that's my
There'll be a period of time.
assumption.
It takes many years, so there might be periods of time when they do want to be getting on, other times earlier when it's not so early. Now, just on the different approaches, what I'm saying to my lord and my lady is that the fact that you see different approaches doesn't mean that the obligation is any different, that FRAND means something different. It's the same obligation, it's the French law contractual obligation. It's just that, just as any assessment of value, there are different approaches that can be adopted, and they will depend upon the arguments and the evidence advanced by the Now, just to be absolutely clear, in my example, what if, as a matter of timing, the patent owner does litigate a patent declared essential, and the determination is that it's not? He's not obliged then to license it. So what I'm talking about, if the patent owner fails on his first suit, but succeeds on his second, at that point in time, he's obliged, as he's always been, to license everything needed to make and sell the equipment. As a practical matter, at that point in time, we know one isn't, one definitely is, and all the others are in the same category as the rest of the example I've been giving you. So the substance of the obligation is that 999 are now needed as a practical matter. And implicit in the argument that's put against me is that I actually have to show that the patent is valid and infringed in litigation before the obligation bites, or at least so far as him looking at the obligation. That actually, if you just stop and think about it, it's contrary to what's set out in Huawei and ZTE. That identifies a scheme where the implementer, having received the patent owner's offer, is to make a counter-offer promptly. Simply not consistent with saying the implementer can simply refuse until after the court has determined it. When we come to it, not only is it inconsistent with that scheme, but when we look at the Advocate General's opinion, we'll see that he expressly says that validity can be challenged, but he's talking about afterwards, after the licence is entered into. And I've now got to the point in my note where I was going to make the point that my lady's already at, which picking off patents one by one isn't actually giving a permission to do any act at all. I'm not permitting anybody to manufacture a phone because I've got another 999 that they're not licensing and that I say are being infringed. And actually, I have another point which stems from a thing that my lady raised yesterday, or probably Monday now, the point about reciprocity. I'll give you the reference. It's in paragraph 6.1, right in the middle of page MS 139. I don't think you need to turn it up because my friend and myself are agreed that it's about cross-licensing. It doesn't happen in this case because my clients don't need a cross-license, but often you are talking about players in the industry who do. And what happens in real life, the parties deal with it in one transaction. Cross-license. And in fact, many of the licenses that the judge reviewed in his valuation exercise were cross-licenses. And experts are able to analyse them and tell you how they show the value of both of the portfolios. But he's quite right, that's what it's about. Why it's of significance to what we're talking about is because it shows strongly in my submission that this scheme is not contemplating single individual patent licenses at the choice of an implementer. It doesn't make any sense to suggest you're entitled to insist on cross-licensing in that context. How would it work? They asked for a single patent. Would you ask for one back? Both still left needing a licence on, say, thousands and thousands left unlicensed. And of course, on my friend's view, if it's just patent by patent, you can just come and ask for an individual patent anyway. What it is about is the ability to say to the other side, we have to sort out this licensing position both ways round in a single transaction. That's of obvious benefit practically, but it actually ensures that people don't take inconsistent positions on matters of principle that you're adopting in this approach. Make sure that a more reasonable party is not taken to the cleaners by concluding a licence with the other side and then being basically strung along and they hold out on the licence where they actually have to pay the money. It has obvious good sense in the context I say is the correct one, but reciprocity is nonsense in my friend's view of the world. And there's another side point that I make about this. The reciprocity point, and indeed the argument that we're not even committing acts, are all matters which should have been considered by the judge and actually pursued in cross-examination with the licensing experts. But they weren't, because this wasn't the argument before the judge. And it rather highlights how wrong it is for my friend to be seeking to come here, add an extra issue to the case and re-argue the true meaning and effect of that French law obligation. Now, in addition, I obviously rely upon all the points about the international nature and the balance required to justify my argument as to why it's global, or at least in some circumstances maybe, because that's all the courts below held. We've seen that in some standard setting organisations they expressly say it is. The ETSI one doesn't say it is, always. The courts below followed an approach which involves assessing the size and depth, breadth of coverage of the portfolio, all the circumstances of the case, and concluded that there will be cases where the obligation is global.
The two key variables, one is the portfolio and the other is the nature of the implementer's business.
Exactly.
Yes.
Exactly. And you've seen in the judgment where the judge looked at that. And of course, it would be a most strange situation if the true meaning effect of the ETSI undertaking is that precisely that which you see expressed in the others is prohibited, i.e. the global.
Well, presumably reciprocity requires that the undertakings are broadly equivalent. I mean, if there is a negotiation going on between one person who's a licensor and an implementer and another person who's a licensor and an implementer to which the 6.3 reciprocity obligation applies, they may be members of different SSOs, mightn't they?
I think we have slight cross-purposes. Reciprocity is between two parties who are both patent owners and implementers.
Yes, no, I understand that. But they may be, but would they necessarily both be ETSI regulated? I would have thought on the face of it, not.
Well, if, for instance, you've got Bluetooth on your phone, so if you're talking about, you might be Bluetooth actually, maybe not, but it doesn't matter. If you've got Bluetooth, which is another standard setting body, you're quite right. There may be situations where you're looking at a reciprocity obligation and seeking to negotiate cross-licensing under two regimes.
Yes.
That's certainly possible. That's all I wanted to say about issue 5. Can I move to the specifics of issue 1 now? Some preliminary comments. I've foreshadowed this already, but the arguments that are advanced because the correct meaning and effect of the undertaking is that the licence should be global. I just want to pause to highlight how peculiar that is. It's not because it's the wrong answer on the disputed FRAND undertaking, it's because it is the right answer. So the jurisdiction arguments are a way of avoiding the actual effect of the undertaking and to frustrate the effect of it and the regimes under which they arise, even though they are carefully balanced. Second preliminary point. These points are being run as a matter of principle. My friend, though, likes to pull in case-specific factors he likes to deprecate the business model of non-practicing entities. We disagree with the criticism, but the more significant point I make is his case is that no patent holder at all is entitled to an injunction. That's everybody, including those active in the manufacture and sale of equipment and devices or their components. So Ericsson or Qualcomm, two of the interveners that you've seen. He also likes to bring in points about what he says about the strength of Conversant's portfolio. But he can't criticise Unwired Planet in that way, and of course his argument is that it applies to everybody, including Ericsson and Qualcomm and anybody else's portfolio. My friend also repeatedly appeals to arguments as to which, on his view, means that the UK court is an inappropriate forum. That is not a legitimate point on this point. My friend's argument on issue 1, or at least my learned friend Mr. Howard's argument, because again this was a point that my learned friend Mr. Block conspicuously does not support, is that no court can do this. Move to try to identify the points put against me. And the first thing I want to do is to just ask what points are being run. What is the position that my friend is arguing for? Because in my submission it is a complete confusion. Printed case doesn't begin to structure an argument that identifies points that go to particular issues. The reply case, at least in some parts, has a stab at it. Let's turn that up. It's in Supplemental Bundle Tab 2, MS 10387. And we've at least got a section headed Issue 1, which is the first section, before they then go off onto the actual undertaking, which is the second section, the issue that I've been calling Issue 5. Just note how it's put there in the heading in the index, so 10387. The ETSI undertaking does not require a global licence. As I've already said to my lords and my lady, it's not the decision of the courts below. It involved looking at the circumstances of the case to see whether the obligation in those circumstances was global. Let's look at some of the key paragraphs in his reply to get a feel for what their position is. First, in the summary, paragraph 2 on MS 10388. It says their position is Huawei ought to be permitted to enter a settled UK licence and the injunction discharged. So pausing there, that is arguing for the UK portfolio licence, country-by-country approach. As you know, that was their stated position in the courts below. So far, so good. If we go to the summary that is said to be the summary of where they get at the end of issue 1, so it's the section right, it's called summary so far. It's para 47 on MS 10399. Maybe I've got the wrong. '10402, sorry. It's paragraph 47. This is the summary of what's gone before in this section. And what this says is the appropriate remedy is damages limited to a UK royalty, not an injunction. Looking at second and third line. And that's what they've been busy arguing through that section. My clients get no injunction whatever. There's no licence. It's patent by patent. But it's the no licence flavour that I identified to my lords and my lady yesterday. Next section seeks to re-argue the effect of the undertaking, advances a further position. It is also patent by patent. Licence under each individual patent, and you can see that, for example, plainly set out in para 62.1 at the top of MS 10408. Right at the top.
The words per patent licenses.
Exactly.
Yeah.
What it's about is ensuring access to per patent licenses to resist per patent injunctions. So what this section is advancing is an argument that it's patent by patent, but the licensed flavour. At this stage, he's flipped, still patent by patent, but now there's a licence. If we skip forward to para 120 on MS 10425, you see the summary there. In the Unwired Planet case, it said that we should be refused an injunction and limited to damages in lieu. So that's flipping back to the patent by patent, but no licence approach. But still nothing to support what's put up front in paragraph 2. The statement in paragraph 120.2, expressed as regards conversant, must as a matter of logic also be something they can say about Unwired too. Claims are no different to foreign patent infringement claims. So I think my lords and my lady realise the claim is very different indeed to suing on foreign patents. We've sued only on UK patents. But the broader point I make is the whole argument flips between different outcomes that are put forward, and none of them, not one of them, supports what's in paragraph 2, which is their stated position. They have no argument at all for the country-by-country approach being the correct answer. But
well, do they seek to resolve it by saying that if you limit yourself to country by country, then all the patents within that country will be subject to adjudication by the court, so that you can effectively do it within a single country, patent by patent? I don't for the moment know whether the settled UK licence in this case was a licence in relation to all the declared UK SEPs, or those which had been established as valid and infringed.
no, it's not limited to only the two that have been established.
It was all the licenses, including all the uncertain ones.
Yeah.
Yes, and so the expression "the settled UK licence" is the licence settled in the Unwired Planet
Yes.
case. Yeah.
And actually, there's a related point about that. But 4 trials that were scheduled. 4 patent trials. And what happened second, one on the third. By the time we were getting close to the fourth, the first one was upheld on appeal. The other two appeals were still pending, and the fourth trial hadn't yet happened. And it was agreed between the parties that there was no point going on with the technical trials. The reason I draw attention to the fact that the arguments don't support his position is not just for the obvious point that he has nothing to say to commend his position, but because I want my lords and my lady to understand that if you accede to his arguments, in future, patent owners will be saying it is patent by patent, either the no license flavour or the license flavour. The reasoning that you adopt any of this, that's what they'll be saying. Try and address the particular points that appear to be being maintained in this document. So what I'm really addressing are the 10 subheadings that you see in the index under issue 1. So that's MS 10387, and each one has a section in the document. They're not actually all separate points, but I'm going to try to go through them and meet them and tell you where I say it's just the same point repackaged. Point 1 is given the heading Main Issue. It's addressed at MS 10394. The point is put in the most tendentious way. It's said that the issue is whether the English Patent Court can and should become the de facto compulsory licensing tribunal for telecoms SEP portfolios. And then it goes on over the page to say that it can only do it in a half-hearted way because it doesn't have powers to determine validity or scope of foreign patents. That's about 5 lines from the end of the top paragraph. It culminates in saying the courts should leave that to the foreign courts. This court is not being asked to decide if the UK court can and should be the de facto compulsory licensing tribunal. As we shall see, other countries grant injunctions on national patents, including cases where the offer on the table from the implementer is global because they decide that the offer on the table from the patent owner, I think I got it round the wrong way, global, because they consider they are conducting themselves reasonably and the implementer is not. The Chinese courts have even done it. A case against Samsung when Huawei was in the position of a SEP owner. There's no basis at all to suggest that the UK court would be setting itself up as the de facto compulsory licensing tribunal. And of course, in this proposition is another big error, which I've covered in my propositions, the idea that licensing requires patent by patent determination of validity and essentiality. It doesn't, for the reasons we've covered. The second point is a suggestion that my case has 3 steps. This is the heading Respondent's Reasoning is Flawed on MS 10395. And it's step 2 and 3 they don't like. And 2 is where they say it only makes practical sense for there to be a global license under all of the patentees disputed patents. This point really is muddling up arguments might arise on the true meaning and effect of the undertaking with a jurisdiction argument. It's got nothing to do with the jurisdiction argument. The premise of the jurisdiction argument is that that is the effect of the undertaking. And I've shown you there are cases where it's written in. So it's not, in my submission, part of the jurisdictional analysis at all. And it's not part of my reasoning either. My argument is simply this. Where a FRAND license is available to the implementer and it is infringing the United Kingdom patent, doesn't take that FRAND license, that which the ETSI obligation obliges the patent owner to offer, in those circumstances the court may properly grant an injunction. Right and the ETSI regime together. His next point is headed Special Cases of Patents Incorporated into Standards. And there's no dispute they're a special case. It's just that what he then goes on to say, he asserts that the relief of injunction should just never be available. That's the substance of the point being made here. You see it in para 27 on MS 10396. He says, if patent owners insist on injunctions, no one would be able to work the standards as of right. That's the second line. Now, I anticipate that my lords and my lady will know what I'm going to say about that. Working the standards as of right is not the effect of the standard setting body's policy. Seen the balance that they're seeking to achieve, and it's only those that agree to accept the FRAND license that the patent owner has undertaken to make a license available. It is not everybody as of right. That's not how the balance is struck. And indeed, if that were so, if you stand back and think about it, there would be no incentive to partake in standard setting at all, because everybody would just hold out, and the very few patents that could ever be enforced in very few countries, safer than those, everyone would use everything for free. That, as I think I've said before, is simply a charter for holdout. Point 4 is headed monetary compensation, not an exclusive right. It's basically the same point. What we see in these paragraphs is a suggestion that the patent bargain must be modified. We see that at paragraph 31 at the foot of MS 10397. So, it's asserted that the normal right to exclude in the patent bargain becomes a reasonable monetary right. That's the top of MS 10398. And as they make clear here, it doesn't depend upon the wording of the undertaking. Absolutely intended to apply regardless. That's why I say it's the same point. They're simply saying there can be no injunction, whatever, it's always just money. Before we leave that point, you see they set out a sentence from the judgment of Lord Sumption in one step, paragraph 32. This is on MS 10398. Step is a case addressing what had rather loosely previously been called Rotham Park damages, I think. Which is in fact several separate categories of damages. And it's the analysis of my Lord Reid, which is the majority, not of that of Lord Sumption. And indeed, there was a conflict between the two, and the whole point of Lord Carnworth's judgment was to identify the difference between the two. My Lord Reid's judgment is that of the majority and is following the conventional approach, and Lord Carnworth described Lord Sumption's as radical. Most crucially for our purposes, although it wasn't central to the case, what the case there was all about, is an analysis that explains the user principle of assessing damages. And it's a method used to calculate past damages for loss of the ability to control property. And it basically works like this, and I'm not now being specific to intellectual property, I'm just talking about any property. If the defendant has taken the property owner's right to control the property, right to exclusive dominion over it, that itself has value. And so after the plaintiff has vindicated his rights and that exclusive dominion is returned to him, perhaps by injunction, the measure of damage for the period when it was taken away is the cost, the rent, whatever you want to call it, the loss of the right to control. And of course the point in one step was in fact contractual, so it's a different category again. But these cases are similar because they're calculated by reference to a notional release fee. But actually they're predicated on different reasoning. And can we turn it up? I'll try and do it more briefly than my note does actually, because I see the time. But can we turn it up? It's Authorities 3. And it's tab 50, so that is MS 5670. And can I just ask you, without asking you to go to it now, to look at Lord Carnworth's reservations as to Lord Sumption's approach, and in particular, when you read it, see that he is not agreeing with taking patents out of the property category. The way in which it's been put forward in my friend's printed case gives you quite the wrong impression that Lord Carnworth is approving of Lord Sumption taking patents out and dealing with them separately. And that's why they want to rely on Lord Sumption saying that a patent owner doesn't have an interest beyond his pecuniary interest. Because in fact he does. And that's the rub. Because he takes it out of the property interest. And my Lord Reid's explanation of the user principle, not involving a pecuniary loss, is actually what's key.
I discussed Lord Shaw's judgment in paragraph 28 in the context of user damages and tort, or 27 and 28. And actually Lord Shaw himself gave the illustration, well, the well-known example of the horse.
The horse is a great example, because it's not only doesn't do you any harm, it comes back better for the exercise.
Yes, yes.
But the whole point is that there's no pecuniary loss, and you can see that from cases like Stoke-on-Trent, which my Lord refers to in that passage. And just another point, what in passing, just to make sure there's no no confusion at all, the Lord Shaw case was a case where an injunction was granted. He's not talking about damages in lieu. He's talking about the past. He's talking about how much you get once the horse comes back, but there's an injunction to stop them taking the horse again. And just to show you that, it's Authorities Bundle 4, right at the beginning of Lord Shaw's judgment. So I'm in tab 76, MS 6478. It explains, it's a Scottish case, so it explains that the appellants were interdicted from the infringement. Mm-hmm. So right in the middle of MS 6478. It's not a case about damages in lieu. Now, my lords, I don't just raise all of this to say that what my friend's doing is illegitimate.
Yes, because the point, it comes back to me, the point was that the infringer was selling in a territory where the patent owner would never have sold himself. And so it wasn't that he had suffered any, the loss he'd suffered couldn't be
Suffered loss.
Wasn't a conventional loss.
Suddenly hadn't suffered any
It was
lost
more like,
sales.
It's more like the unauthorised use of a horse.
Exactly.
Yeah.
And there's another case that says if you take a chair out of my room...
Yes. There's no answer to say that there are plenty of other chairs you could sit on.
Sat on it. And these are all cases where there is no pecuniary loss. Absolutely not. But and the reason that I deal with this in a bit more detail is not just to say that my friend doesn't get what he wants out of it. It actually goes a bit further than that, because the whole reasoning of the user process, the user principle, is predicated on the fact that you do have the right to exclude. That's what's been taken away from you. So it's compensatory, to be sure, but it's that loss of the right to control, the loss of the exclusivity of the dominion over your property, your horse, your chair, or your patent, whatever it may be. Damages in lieu of an injunction in future. Indeed, as you've seen in Lord Shaw's case, there was an injunction, and the case is really predicated on the assumption that there will be.
You're going to tell us the paragraph in Lord Culmouth's judgment in one step. You may have done, but I didn't note it. It's just the paragraph number if you've got it in your notes, not to look it up again. No, it's a small point. Don't take up time.
I will find it over lunch.
Yes, sure.
I know it's in my note. I've just skipped forward a few pages.
Yeah, don't worry.
You had us at 128, which is...
This was MS 5670.
Yeah.
Was where we were.
Yes.
Thank you very much.
Actually, let's look at it quickly. 135.
So it's MS 5672. The sentence they've quoted in the footnote in their printed cases, as Lord Sumption fairly says, a patent infringement, although involved with property right, is not the same as appropriation of a user's use of another's land or chattels. They like that. They don't give you the next sentence.
Yes.
Yes. Yes, as he says at the beginning, if you were turning back the clock 100 years, you might take a different approach.
The sense of that paragraph is completely the opposite. And actually, I regret that some of the time that I'm going to have to take is correcting things like that. Can we revert to my friend's points in his reply? I think the next one is headed monetary compensation for use of a UK right is royalty for the use of that right. That's just one paragraph at paragraph 33 MS 10398. And that's actually also just the same point as the previous one. It's assuming that there's no injunction available even where the FRAN licence is not taken. Next point at the foot of MS 10398 is the suggestion that the injunction cannot change a national right into a global right. Now there's an attempt to suggest that my Lord readers approve something of substance from Lund Poly. You see that in paragraph 34. That is in fact a reference to my Lord's judgment, paragraph 3, where you just say you're going to use the term negotiating damages that Lord Neuberger put forward in Lund Poly. I'm afraid that's another attempt to construct some edifice on a quote that doesn't come close. But again, the complaint in this paragraph is premised on an injunction not being awarded even if the FRAN licence the patent owner has undertaken to offer is not taken. The nub of it is the contention that the national patent is changed into a global right. That is not right. It's the same national right. In fact, there are two important ways in which it's lesser. It's a lesser restricted right. Let me explain to you what they are. First, the patent owner, his ability not to agree to license at all has been removed. Second, the terms of any licensee agrees cannot be set however the patent owner likes, which is the normal case. Restrained on that as well. In ordinary cases, a patent owner has both of those abilities. It's important to understand that because the fact that property rights, if enforced, may have a knock-on effect, that parties settle other disputes, happens every day. It doesn't turn those intellectual property rights into global rights. UK patent is a UK-only right, and that is it. And in fact, the next 2 points too are really the same, the substance of the points are the same. The next point is paragraph 37, entitled "An injunction is not granted to settle other claims." MS 10399. Do that in that its purpose. If that's what happens, because the property owner is entitled to an injunction, that's what happens. In fact, as far as I can tell, what this submission is directed to is not the injunction, but its limitation, which is actually there for their protection. I'll tell you why I make that submission. Look at the example my friends give. It postulates two separate contractual disputes, and that the court is determining one and ordering specific performance, but that order to be discharged if the other dispute is compromised. This is the middle of paragraph 37. But he says, even if the order for specific performance might actually be justified anyway. So he's talking about a situation where the claimant is entitled to it, just below halfway down. talking about a situation where you should have it, but actually what the court does is put a limitation on it. There's nothing wrong with the order for specific performance in my friend's example. It's the proviso. It's his premise is that otherwise it would be justified. It may well be. Pause and think about it. The injustice he's talking about is not an injustice to the defendant, but to the claimant. That's because the order, which the claimant is otherwise entitled to, is limited so that he loses it if he compromises the other action. If he had the order unlimited, he can choose if he puts it in the pot to negotiate the other claim. Choose. I have an order for specific performance, I've got another claim against you, now let's have a talk. He can decide to negotiate that away or not. He's entitled to it. What the order postulated by my friend doesn't make the defendant's position worse, but the claimant's position worse. And the right answer is simply the order for specific performance without the proviso. The equivalent in our case would simply be an injunction, as actually happens in other countries. Interested to see, if you ask him in reply, whether he'd prefer an injunction without the qualification. I think we know the answer will be no. But to be clear, it's up to him. It's no skin off our nose. The same point is underlying the next point at para 39 on MS 10400. Headed injunction is not granted to enforce foreign patent rights. Same point repackaged. The injunction is simply enforcing the national right, the right which has been found to be valid and infringed. So I have to say the quote relied upon by my friend in para 39, this is MS 10400, is entirely misplaced because it does equate to the national right. Also, the reliance on Kirin Amjin is the same point. That was an attempt to secure injunctive relief to restrain activities outside the United Kingdom as a kind of springboard relief. That is, to restrain activities not actually in the scope of the patent, but made possible by the acts carried out in infringement. I don't know whether my Lord and my Lady know, but normally in patent actions where we talk about springboard relief, the idea is it's a post-expiry thing. So if somebody builds up a headway into a market, infringing, and you get a final decision after expiry, there may be an issue as to whether you get an injunction to hold them back from exploiting that unlawful head start. That wasn't this case. This was a genetic engineering case about an attempt to say that kind of idea also applied to the use of genetically engineered cells or protein that had been taken out of the country. So it's all about an injunction to restrain activities abroad. Nothing to do with what we're talking about here.
All the quote says so in terms.
Exactly. Very briefly, footnote 19 on that paragraph, they're interim injunction cases. They're basically to do with applications at a stage where the scope of the monopoly isn't yet determined. It's nothing to do with territory. It's to do with what kind of losses might be recoverable for the purposes of assessing whether damages were adequate on the cross-undertaking. The next point is a specific complaint about damages for the past. It's a complaint again predicated on the incorrect premise that the right approach is damages in lieu of an injunction. And actually, I think it's also predicated on the idea that licence royalties, in this case for the past, are damages for specific past infringements. So I've covered those points, but I think they're built into this. I go further, though, and say this. It's not actually a complaint that goes to the point of principle we're debating at all. At most, it's a point that in future cases, say conversant, could be raised and determined by the judge. As a matter of commercial practice, that's how things are done. And let me say this, it's more than just convenience. It's to do with the reality of what's going on when parties negotiate. I've already told you implementers like delay. They always say, however many years into the attempt to negotiate you are, and generally it's many years, that they were sued too soon. And it's quite extraordinary for an implementer to say we can take years to negotiate while infringing unlicensed. But I also want to exclude that period from the licence. They certainly never could say that with a straight face while maintaining the stance that they're in fact, at that negotiating point in time, a willing licensee. Then they say, look, I really do want the licence, it's just a matter of needing time to negotiate the terms. But the substance of what's being complained of or suggested is that later on they can turn round and say, actually, I'm not a willing licensee for that period when we were negotiating. I don't want to pay. It's a thoroughly bad point, but in any event, it's not a point that goes to the principle we're debating. Final point Huawei maintain is a point on proportionality. This is para 45 on MS 10402. And the criticism was the court failed properly to consider whether an injunction rather than damages in substitution for an injunction was the appropriate remedy. They say that in terms at the start of paragraph 46. So to be clear, the criticism is the failure to consider a Lord Cairns Act damages in lieu order. First point I make about that is the argument was never advanced. You don't come to an appellate court, particularly not this court, say the judge failed in the exercise of his discretion. Kinchin and the others, the Court of Appeal got it all wrong. Not doing something, not considering something he didn't ask for. But actually, I'll go further because the substance of the argument can be seen from the end of paragraph 46. The argument is said to be the balance on the one hand of the fact, so they say, the UK royalty would compensate the patent owner against the huge disadvantage on their side of requiring them to withdraw from the market. First point I make about that, what's missing from that? What they leave out of that balance is the fact that the FRAN licence is available from the implementer to take. Point that Mr. Justice Burst really emphasised when deciding these matters. You look at para 793, core volume 2, MS
790?
Para 793.
Yes, but what's the MS?
I've got the MS the same, that must be wrong.
I don't know. Try.
No, I think it's right. Paragraph 793 on page 793.
Oh, no.
Really?
I was certain that wouldn't have been a coincidence. I'm grateful to my Lord. Should an injunction be granted is the heading. Why does he say it should be? Because they're standing before the court without a licence, but have the means to become licensed. The availability of the licence is crucial in this assessment, but they don't even refer to it. Actually, I can go even further, because the substance of what they are trying to argue was in fact the substance of the debate as to whether the FRAND licence required from the patentee should be a global one. So in fact, what the argument is really seeking to do is to just rerun that same assessment, but give it a new Lord Cairns Act label. And of course then, I rely upon all the points that I've identified already as to the balance, the fair access to implementers and so forth. I don't ask you to turn it up, but it's all the matters that you've seen already in Lord Kitchen in paragraphs 54 to 56. Just for your note, MS 497. And actually, just when you do read that, bear in mind that what my friend is arguing for is even worse, because Lord Kitchen is considering my friend's stated position, country by country. What he's now putting forward and saying damages in lieu should be is patent in suit by patent in suit. And as I think you've already got, I say that doesn't just apply to me, it would apply to parties such as Qualcomm. People with portfolios of that size. Its patent portfolio is the fruit of over $60 billion of investment. Its portfolio is huge. We don't know the precise numbers, but we can be sure that it will have very, very many SEPs just in the UK. Several hundreds, if not into the thousands. But on my friend's argument, they get nothing other than damages on lieu on individual patents that they sue on. Can I turn to ZTE's arguments against me on issue 4 as I understood them? Issue 1, sorry. As I foreshadowed before, ZTE don't support the arguments put forward by Huawei at all. They accept that patent claims advanced they accept that these are patent claims advanced in the UK courts, which is the appropriate court. I don't ask you to turn it up, but I give you the reference. It's in their reply. So it's tab 3 of the supplemental bundle on MS 10440, para 22. ZTE also fairly and correctly accepts that the ETSI undertaking is contractual. I take issue with some of the specifics as to how they characterise it, but they in substance agree that it's contractual, and I give you a reference there is para 17 in the same document, MS 10439. Actually, having said let's not turn it up, I've realised that I'm going to be taking you to some other paragraphs, so let's just open it up if we can, please. It's tab 3, supplemental bundle. The document itself starts on MS 10434, and the reference I was just giving you is on 10439, para 17 at the top, where they say it is contractual. And actually, if you go back a page to 10438 to paragraph 15, you see they also accept, this is 3 or 4 lines from the end of the term of that the terms of the FRAND licence are an issue in Conversant's claim for injunctive relief. They try to say perhaps only potentially, but it's obvious they definitely are. Unlike Huawei, who seek to argue that this is no different to bringing claims for infringement of foreign patents, ZTE take a more realistic view in my submission, that it's a contractual issue that arises in claims for infringement of UK patents, in particular the relief of injunction over those patents. Another important point, if you look at paragraph 30 on MS 10422, 442, is my friend recognises and is accepting there that his jurisdiction objection is predicated on the premise that the correct answer to what FRAND is global. Accept the rest of the point that he's making, but it is quite clear that he's recognising that that is the premise of his argument, and he's right about that. So what is their argument on issue 1? Because it's certainly not the same as Huawei's or anything like it. As I understand it, first it said that there's a declaratory claim for determination of FRAND terms, and that's why we have two headings, FRAND claims and patent claims, on pages 6 and 7 of the document, which is 10439 and 10440. And the point I understand being made is to say that the issue of validity and essentiality of UK patents is an issue in the FRAND claim. You see that in paragraph 15, at the beginning of the paragraph I just showed you. Now, we disagree with that, as you will have understood from what I've said to you earlier. FRAND terms don't depend upon validity infringement of any particular single patent. That's in my propositions. But my friend's setting the contention up so that there are two separate claims and trying to say that each claim is itself an issue in the other. And I think what my friend is then seeking to suggest, although it's not at all clear, is that if the case was just a freestanding declaratory claim, i.e. if there was no patent claim, no reliance on the FRAND undertaking as a defence to the injunction, then there would be an argument that the court would not exercise jurisdiction over such a declaratory claim. I think that's what he's setting up and arguing by referring to TQ delta. That's in paragraph 20. But in my submission, that's to postulate just a different scenario. If there is a freestanding declaratory claim, there's no connection to the UK at all, because in TQ delta, it was made absolutely clear by the implementer they would never enforce the ETSI undertaking. Just a different scenario. It's certainly no answer to this case, where the ETSI undertaking does arise as an issue. It is a defence to the injunction, and it is a contractual dispute, which is not contended to be non-justiciable as such. Another point that appears to be floated by ZTE as an argument on this issue 1, as I've understood it, is that it may be unfrand to sue in particular courts. That, in fact, is wholly the argument in this court, perhaps even new in the reply case. I certainly did not see it articulated clearly before. But it's paragraphs 34 to 38. And you see, particularly, say, for instance, in paragraph 37 on MS 10443, that it may not be FRAND to enforce patents in particular courts. That's the allegation. Can we just pause and unpack that idea? The idea is that on top of the Huawei and ZTE guidance directed to how to avoid allegations of competition law breaches when taking the step of suing, There's in fact some additional restriction on patentees preventing enforcement of some of its patents at all. And I say it prevents enforcement of its patents because although it's put in terms of enforcing in particular courts, patents have to be enforced in the country where they're registered because validity is always put in issue, and so that is the effect of that suggestion. And in fact, one assumes that the point is really, in this case, a suggestion that suing on anything other than Chinese patents is anti-FRAND. So what is really happening with this argument is my friend is trying to import into the jurisdiction arguments, this forum convenio arguments, but actually putting the patent owner in an even worse position because they can only enforce the patents in the jurisdiction the implementer chooses. My criticism of that argument doesn't stop here. The argument is, or the obligation is said to come from the FRAND undertaking. That's an undertaking to offer licenses on FRAND terms, as we've been debating. It's one thing to say this includes a requirement on the bona fides of conduct in offering and counter-offering. Quite another thing to say that the undertaking to offer licenses is actually an undertaking not to sue on the vast majority of patents at all, because that is what this argument amounts to. In fact, I go further. If you stop and think about it, it's not a jurisdiction challenge as such, certainly not the one that was made in the application notice or the courts below. That was the contention that we're enforcing foreign patents. Why I say that is because it involves making an allegation as to the FRAND obligation and its breach. So it actually involves getting into deciding the merits as to the FRAND obligation and deciding that Conversant is in breach of it. If it's a point not of jurisdiction, but it's a point that would have to be taken in the action, summary judgment or trial or perhaps a preliminary issue, but it's not. It is deciding the merits of FRAND. The final point I make about the reply case is draw attention to my friend's para 38. This is MS 10444. And I have to say, I've got some difficulty in understanding what's proposed, because it said here that the court can decline to exercise jurisdiction over a claim in relation to terms of global FRAND, at the same time uphold the patent rights to which such a licence would relate, if and insofar as it's the appropriate forum as from a FRAND perspective. It just simply doesn't address how one determines the patent claim, and certainly how you would uphold the patent rights, which include considering whether to grant an injunction. They don't say so, but one rather assumes they're proposing they win by default, that there shouldn't be an injunction. So that doesn't really help in my submission. My ladies, I see the time. I've actually got to the end of what I want to say on the points put against me on issue 1.
Yes.
I'm going to move on to the foreign law and comity.
Yes.
Quite a chunky part of my submission straight after lunch, if that's convenient.
Very well then, 2 o'clock.